So it will be the 19th. Yes.
We have our
if
own
you
mother
need to make
tongue,
these dates in
which
order of
is our
court,
own
then you can do
identity.
so
If you want to
at the
remain
conclusion of today's
substantial, if you want to
proceedings.
remain relevant,
Otherwise,
you have to embrace your roots. You have to
that is what has
embrace
been
where
agreed by
you
the
are
parties.
from. So if your name is Badegeshi, there's no way you will speak any
agreement.
kind of phonetics in my ears that it would
Yes.
sound, yeah? Even
Very
if you
well,
were
thank you.
born, buttered and bred in the UK, you still
Well,
have
then
that
just
name
one
that
domestic
betrays
matter.
you
We didn't
as
mention
this.
to
It
your
doesn't
lordship in
betray you, but
chambers that the parties
it tells us
would prefer
this
a
is
running
who you
record.
are.
Educationists have
your lordship
emphasized the need to
indicated that,
integrate the
finances
African
should be
culture,
arranged between the
particularly the
parties,
languages,
and
into
that
the
the
school
court may make a
curriculum
effect.
in a bid
So
to
I
ensure
propose
that
that your
African
lordship,
values and
either
traditions
now at the
are
close
not
of the proceeding
completely
makes such an order,
eroded.
and we will reach an agreement
Well,
relating to the finance.
I might as well deal with
We
it
can
now.
start
It's directed
just as
then
a
that a running
basic,
record will be
foundation
prepared of the
step
proceedings,
is to strengthen
but the
efforts
financing
to
thereof will be
indigenous
resolved
languages in
amongst the
schools,
parties.
provide the material that's needed, and in that way that'll have ripple effects
my lord,
in
then that
society,
deals with the
because when
preliminary
children
matters,
engage
as
with
it
the
were.
language, they engage with
And
the
the
culture,
state
they
is
learn
ready to
about
put
it,
the-
they go
to put
home,
the
and
indictment
when
to
you
the
do your
accused.
homework, you ask your parents,
Before I do that,
then you hear stories
I'm
from your
obliged
grandparents.
to
So I think
make sure that the indictment
teaching
is properly put,
the indigenous
and to do
languages
that, there are
is a very,
two
very
documents
is a very
which I need to hand up
important step
to your
that will have
lordship.
ripple effects
The
across
first
border
is
societies
the
in familiarizing
centralization
children with their
certificate
culture and tradition.
signed in
If we want our
2008 by
children to
then
carry
acting
on in what we believe
NDPP,
in, which is our
Mr.
culture,
Mshere.
traditions, norms, and lifestyle, I mean, the
if you just hand
only
that up, my lord.
sensible way to
Yes,
go
we
about
started
it
last
is
time
to
with
leave it out
Exhibit A. Shall
for
we
them,
give this
leave
an
it out
Exhibit
for
B?
them
yes.
in
And
terms
then
of
at the
daily
same time, I'll hand up
lifestyle,
Exhibit
the
C,
things we engage
which is the
them
racketeering
in, the
authorization
exposure we
certificate,
give them,
which, as your
and
lordship-
all round a balanced exposure altogether.
my
With
learned
this
friends
year's
have copies.
theme being art,
So
culture
just
and
to be clear,
heritage,
the first one is a
levers
certificate
for building the Africa we
authorizing
want. Africa
the,
must continue to promote and share the
centralization of
African
these charges,
ideals of cultural
where
renaissance,
some of the charges
hard
were
work,
some of
and
the
Ubuntu.
offences were committed
Omolola
in
Ololade,
jurisdictions other
reporting
than
for News
the
Central.
KwaZulu-Natal division. So that has been authorized. If I could just look at it, Mr. Mshere authorized this
Still
in
ahead,
2008.
on the news, United Nations HAPS on need to protect civilians in crisis situation.
And all the charges
Details
are
after
mentioned
this.
in terms of which centralization is sought. If we just go down, this is an old authorization, including a previous accused number 3. So the offences which are committed in Linwood, the Witwatersrand and other places, they're all centralized to this division of the High Court.
Yes.
I don't think it's controversial at this stage, my lord. Secondly, the poker certificate, the racketeering authorization certificate, signed by Mr. Abrahams, the then National Director of Public Prosecutions. This is Mr. Abrahams' authorization, where he, in terms of Section 2.4 of the Poker Act, he authorizes the institution of a prosecution against the above accused in respect of Section 2.1e of the Act committed during the period. The period is given 1995 to 2005. So this just formalizes and authorizes me to put charges relating to the Prevention of Organized Crime Act, racketeering, to the accused. Your Lordship will be aware that this was a subject of a litigation before the full bench of this division, and it was decided in the state's favor. So that being so, my lord, it then falls to me to put the indictment.
Yes,
to
copies
accused
of these have been supplied to the accused, is that correct?
Yes, my lord,
Yes.
they're in possession of it
And,
also.
yeah, Mr. Mpofu, you confirm that, and you've got nothing to add at this stage, and Mr. Roux as well.
Yes, Mr.
Thank you. Yes, I think you may then proceed to put the charges,
Thank you, my lord.
or the indictment.
Yes, with the court, I'm going to put it to the accused, so in the court's hands as to whether the court wishes the accused to stand or whether they could do so at the end.
I think they can stand. They can stand at the end. It's
Yes.
yeah.
Because I'm going to ask them to plead to each charge. There's some 16 of them individually.
Very well.
So, my lord, and for the court's convenience, the court has a copy of the indictment in the file. I'm going to skip from the preamble and go straight to the nub of the charges, which begin at page 65 of the indictment. That is where the charges start. The first count, my Lord, which I put to accused number 1, Mr. Zuma, and accused 2, Thales, and I use the shortened form of Thales' name.
Very well.
This is a count for contravening Section 2(1)(e), read with other sections of the Prevention of Organised Crime Act, and the name of the crime is conducting an enterprise through a pattern of racketeering activities in contravention of Section 2(1)(e). It is alleged that from a date prior to October 1995 and continuing thereafter to the 1st of July 2005, and at Durban, in the district of Durban, the accused, whilst employed by and or associated with an enterprise, to wit, the Nkobi enterprise described in the racketeering preamble, conducted or participated in the conduct, directly or indirectly, of such enterprise affairs through a pattern of racketeering activity, to wit, the planned, ongoing, continuous or repeated participation or involvement in any of the predicate offences as set forth in Racketeering Acts 1 to 1582, which are contained in the indictment, including the commission of 2 or more of the predicate offences. Could I then ask Mr. Zuma, how do you plead?
Mr. Zuma?
Perhaps I could cut my letter short. Yes. If I could put all the charges, then I could plead right at the end.
I think that might be easier. Does Mr. Zuma have a copy of the indictment? Okay, so you can follow as it's being read out. Yes, very well.
Thank you, my Lord. I understand there will be a written plea as well.
Yes.
A written plea from my learned friend, so that will move things along. Count 2, the court will see that count 2 is framed only against accused number 1, Mr. Zuma. The state alleges that Mr. Zuma is guilty of the crime of corruption in contravention of Section 11B, read with Section 3 of the Corruption Act 94 of 1992, in that during the period 24th of October 1995 to the 1st of July 2005, and at Durban, in the district of Durban, accused 1, upon whom the powers had been conferred and who had the duties as set out in the preamble, unlawfully and corruptly received the above-mentioned schedule and or service and or facility benefits which were not legally due from Mr. Sheikh and or the other entities mentioned in the schedule, in order that he should commit or omit to do any act in relation to his powers and or duties to further the interests of Sheikh and or the entities associated with Sheikh and or the Thompson CSF Group and or accused 2 and or the former accused 3 as set out in the preamble, and or to be rewarded for having committed or omitted to do any act constituting any excess of such powers or any neglect of such duties as set out in the preamble. The indictment notes that the total scheduled payments from October 95 to July 2005 were 783 payments in the aggregate of 4.072 million. The alternative count, again, only against accused number 1, so that is basically receiving bribes. The alternative counts are 2 sub-counts. The court will be aware that during the period of this, of the commission of these offences, the law changed. A new act came into being. There's uncertainty about whether the old act continued to apply or whether the new act replaced the old act for the later period. So if the old act is not applicable, we put sub-counts 1 and 2, which are basically the same counts as the main count, except broken up into different periods. So sub-count 1 is the same charge. Accused is charged with contravening Section 11B, read with Section 3 of the Corruption Act, the old act, in that he received bribes, so the indictment reads, up to the 26th of April 2004, which was the date of the coming into force of the new act, having received 606 payments in the aggregate amount of 3.015 million. Subcount 2 then is also corruption for receiving bribes, but in terms of the new act, the 2004 Act, which came into force on the 12th of came into force in 2004. The charge is that during the period 27th of April 2004 to the 1st of July 2005, at the same places as in the main count, the accused directly or indirectly and wrongfully accepted and agreed or offered to accept the gratifications, being the service and or facility benefits and or the schedule benefits specified in the schedule from 27th of April onwards, 2004, as mentioned in the schedule, in order to act personally or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized or biased exercise, carrying out a performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or other obligation, and or that amounts to the abuse of a position of authority and or breach of trust or the violation of a legal duty or designed to achieve an unjust result, or that amounts to an unauthorized or improper inducement to do or not to do anything, to wit, by furthering or having furthered the interests of Sheikh and or the entities associated with Sheikh and or the Thompson CSF group and or accused 2 and or the former accused 3 as set out in the preamble. Alternatively to subcount 2, there's a count of receiving an unauthorized gratification by a person who's party to an employment relationship in terms of the new Corruption Act for the new period. That's from the 27th of April 2004. It's a contravention of Section 10A of the new Act. That is that the accused, being a party to an employment relationship, directly or indirectly accepted the unauthorized gratifications for the period 27th of April 2004 onwards, as mentioned in the schedule, from another person to wit Mr. Sheikh and or the other entities, either for his benefit or the benefit of another person, in respect of his doing any act in relation to the exercise, carrying out, or performance of his powers, duties, or functions within the scope of his employment relationship, more particularly as described in the preamble. That deals with count 2. Now, Lord, count 3 is the exact mirror image of count 2, in that count 3 has a main count of, in respect only of accused number 2. Count 2, for clarity's sake, is the receiver of the bribes. Count 3 is the payer of the bribes. So the contravention is Section 11A of the old Corruption Act of 1992, in that during the same periods, accused number 2, in exactly the same manner as count 2, paid the bribes in the same amounts as I've already mentioned. My Lord, I'm going to cut it short and not go into further detail. In the alternative to count 3, as separate counts, they're the exact mirror image of the sub-counts to count 2, except this time the contraventions are broken up into Old Act and New Act. It's exactly the same as count 2. Other than that, here, the counts are in terms of 11A, and that is the being the against accused number 2, that's Thales, being the payer of the bribes. I'm going to cut it short. Subcount 2 is a contravention of Section 3B of the new Act, and is exactly mirrors the previous receiver counts. There's a mirror image is subcount 2, whereas the previous subcount was receiving an unauthorized gratification. Subcount 2 to count 3 is paying the unauthorized gratification with exactly the same dates and the same amounts. We now move to count 4, which the state puts against accused 1 only. That is that the accused is guilty of the crime of corruption in contravention of Section 11B of the old Corruption Act 94 of 1992, in that during the period 30 September 1999 to 2001 in Atterbury, Durban, accused 1, upon whom the powers had been conferred or had the duties as set out in the preamble, unlawfully and corruptly agreed to receive and or received and or obtained or attempted to obtain the said annual benefits, which were described in the preamble, which were not legally due from Thompson CSF and or accused 2 and or the former accused 3, and or with the assistance and or through the intermediation of accused 2 and the former accused 3, with the intention that he should commit and or omit any act in relation to his powers and or duties to further the interests of Thompson CSF and or accused 2 and the former accused 3 and or Sheikh and the Nkobi Group and or the entities associated with them as set out in the preamble, and or to be rewarded for having committed or omitted to do any act constituting any excess of such powers or any neglect of such powers as set out in the preamble. The annual benefits are described in the preamble, my Lord, as 500,000 rand per annum until the payment of ADS dividends. Count 5 is against accused 2 only. Count 5 is the exact mirror image of count 4, the only difference being that this is a contravention of section 11A as opposed to 11B, so it's 11A of the old Corruption Act. The times, dates, and amounts are exactly the same, except that this relates to accused 2 as the payer and not accused 1 as the receiver. I then move on to count 6 with the leave of the court. This is against accused numbers 1 and 2. The state alleges that the accused are guilty of the crime of money laundering in contravention of section 4, read with other sections of the Prevention of Organised Crime Act, POCA. We say that whereas the accused knew or ought reasonably to have known that property, to wit the annual benefits of 500,000 rand per annum, as described in the preamble, was or formed part of the proceeds of unlawful activities, to wit the crimes or contraventions of the law mentioned in counts 4 and or 5, and in that during the period prior to 30th of September 1999 to 2001, and at only Durban and or Linwood or Waterkloof in the district of Pretoria or Midrand, in Sandton or Paris, France and or Mauritius, and or other places both within and outside the Republic unknown to the state, the accused, acting in the furtherance of a common purpose, wrongfully and unlawfully, entered into an agreement or engaged in an arrangement or transaction and or performed any other act with one or some of the following, with one or some or all of the following, with each other, with the former accused 3, with Mr. Sheikh, with other relevant entities in the Nkobi Group, with Thompson, with Mr. Perrier, with Mr. de Jomeron, with Mr. Tetard, with Thales International, in connection with the said property, to wit the agreements, arrangements, transactions, or other acts mentioned in the preamble, and or payment of the bribe by covert means, and or the so-called service provider agreement, and or the Nkandla development, and that this which had or was likely to have had the effect of concealing or disguising the nature, source, location, disposition, or movement of the said property, or the ownership thereof, or any interest which anyone may have in respect thereof, and or of enabling or assisting one or more of, or some of the following, all the persons previously mentioned, or entities mentioned, who had committed or were committing an offence, whether in the Republic or elsewhere, to wit, the offences mentioned in counts 1 and or 2 and or 3 and or 4 and or 5, and or any of the alternatives or subcounts, that the effect was to avoid prosecution and or to remove or diminish the said property acquired directly or indirectly as a result of the commission of the said offence. And all that, my Lord, is put as money laundering. Alternatively to count 6, both in respect of accused numbers 1 and 2, that the accused are guilty of the crime of the acquisition, possession or use of proceeds of unlawful activities in contravention of section 6, read with the other sections of POCA, and it goes on to describe in very much the same terms as the main count to count 6, the receipt, the acquisition of the property being the proceeds of crime. I'm not going to go into any further detail. The terms are clear. We now move to a series of other counts which are put only against accused number 1, Mr. Zuma. The first is count 7. This is a count of fraud. It is put that in that during the period 18 June 1999 to 14 June 2005, and at near Durban or Cape Town, the accused unlawfully and with intent to defraud, falsely, and to the prejudice, either real or potential, of the Registrar of Members' Interests and or Parliament, gave out to the aforesaid persons and or institution, in his declaration of financial interests, in terms of the Parliamentary Code of Conduct in regard to financial interests, that he had received no financial sponsorships or assistance and or other benefit of a material nature for the above-mentioned period, and or failed to disclose to the above-mentioned persons and or entities, when there was a legal duty so to disclose, that he had received financial sponsorship or assistance and or other benefit of a material nature for the above-mentioned period. Whereas, in truth and in fact, he well knew that he had received the financial sponsorships or assistance and or benefits, being the service and or facility benefits and or the schedule benefits mentioned in the schedule from the 18th of June 1999 to 14th of June 2005, which benefits were of a material nature, the aggregate of the undeclared schedule benefits being 676 payments in the amount of 3.126 million rands. Count 8, again, only in respect of accused number 1, is a count of fraud, in that during the period 28th of September 2000 to 14th of June 2005, and that in Durban or Cape Town, the accused unlawfully with intent to defraud, falsely and to the prejudice, either real or potential, of the Secretary to Cabinet and or to Cabinet, gave out to the aforesaid persons and or institution, in his declaration of financial interests, in terms of Section 5, read with other sections of the Executive Ethics Code, promulgated in terms of the Executive Members Act, he pretended that he had received no financial sponsorships or assistance and or other benefit of a material nature for the above-mentioned period, and or failed to reveal to the above-mentioned persons or entities, when there was a legal duty so to reveal, that he had received financial sponsorship or assistance and or other benefit of a material nature for the above-mentioned period. Whereas, in truth and in fact, he well knew that he had received the financial sponsorships or assistance and or benefits, being the service and or facility benefits and or the schedule benefits from September 2000 to June 2005, which benefits were of a material nature, the aggregate of the undeclared schedule benefits being 613 payments in the amount of 2.813 million. Count 9, again, charged only against accused number 1. This is a count of fraud, in that during or about the 12th of March 2003 in Atonia, Cape Town, the accused unlawfully and with intent to defraud, falsely and to the prejudice, either real or potential, of Renette Taljaard MP and or Parliament, gave out to the aforesaid person and or institution, in a statement to Parliament, in response to a question by the said Renette Taljaard MP on the 14th of February 2003, that he had not met with Sheikh and Tetard in Durban on the 11th of March 2000, nor with Tetard on any other day other than to discuss legitimate matters relating to his portfolio, and or failed to reveal, when he had a duty so to reveal, that he had met Sheikh and Tetard on the 10th of March 2000, if he had not met them on the 11th of March 2000. Whereas in truth and in fact, he well knew that he had met with Sheikh and Tetard in Durban on the 11th of March 2000, alternatively on the 10th of March 2000, and that he had met Sheikh and Tetard on either the 10th or 11th of March to discuss the payment of a bribe, which matter to his knowledge did not relate to his legitimate portfolio, and or that he had met Sheikh and Tetard on either the 10th or 11th of March to discuss the acceptance of money other than relating to his legitimate portfolio. Counts 10 to 18, I now move on to these counts, my Lord. Mr. Zuma is charged alone with counts 10 to 18. These are counts of fraud, in that on the dates which are specified in Annexure A to the indictment, and these dates stretch from 11th September 2003 to 27th of June 2005 in terms of Annexure A. And that in Durban, when accused one unlawfully and with intent to defraud, falsely and to the prejudice, either real or potential, of the Commissioner of the South African Revenue Service and or SARS, he gave out to the aforesaid person and or institution in his income tax return for the tax year ended 28th of February for each of the years mentioned in the annexure, that the income tax return for the income tax period mentioned and set out in the annexure was true and correct in every material respect, and or that the accused had a gross income that excluded the amounts mentioned in the annexure, that the said income tax returns reflected all gross income earned by accused 1 during the said tax period, and or he failed to disclose the said amounts in the income tax returns for those years, that there was a legal duty, when there was a legal duty on him to disclose all income earned by him during the said tax periods, and he did then and there, by means of the said false pretenses and or failure to disclose, induce the said Commissioner of SARS to their actual or potential prejudice, as aforesaid, to believe the false representations and or to fail to take into account the amounts mentioned in the annexure for the purposes of accused 1's income tax assessments and or to assess accused 1 in amounts that excluded the amounts mentioned in the annexure. Whereas in truth and in fact, when he gave out a pretended, he well knew that the said representations were false and that the income tax return for the income tax period mentioned in the annexure was not true and correct in every material respect, and or that the accused 1 had a gross income more by the amounts set out, that the accused had a gross income more by the amount of the notional interest that would have been charged on the interest-free and or deferred interest portion of the payments that had been mentioned in the schedule in the event that such payments were loans, resulting in the additional tax liability which is set out in detail in the annexure, and that the said income tax returns did not reflect all gross income earned by accused 1 during the said tax period, and that he thus did commit the crime of fraud. We put in the first alternative to each of the counts 10 to 18 charges in respect of the Income Tax Act, Section 104(1)A, read with Section 66 of the Income Tax Act of 1962, in that on those same dates and at and near Durban, the accused unlawfully and with the intention to evade assessment of taxation made or allowed to be made false statements or entries in income tax returns for the tax years mentioned, and the details then are the same as in the main count. In the second alternative to each of counts 10 to 18, it is alleged that accused 1 is guilty of contravening Section 75(1)(c) of the Income Tax Act of 1962, in that on those dates in the annexure and at and near Durban, he unlawfully failed to show in the returns mentioned made by him and or on his behalf the gross income mentioned in column 4 and set out in the annexure. And then failed to disclose to the Commissioner of SARS, when he made the returns, any material facts which should have been disclosed, to wit, his gross income in the event that the scheduled payments were loans, the taxable portion of the scheduled benefits. In the event that the payments mentioned were loans, such payments should have been but were not reflected under assets and liabilities in the income tax return. And in the event that such payments were donations, such payments should have been but were not reflected in Part 13 of the said income tax returns as receipts. My Lord, that then concludes the putting of the indictment to accused numbers 1 and 2.
Yes, Mr. Zuma, could I ask you to stand, please? Mr. Zuma, could I ask you to stand, please? You have followed the charges that have been put to you now from the indictment, am I correct?
Yes.
And no doubt, in consultation with your legal representatives, these charges have been explained to you. You understand what they entail.
Yes, I do.
May I ask you then as to how you plead to the charges that have been put to you, which are respectively counts 1, 2, 4, 6, 7, 8, 9, and 10 to 18, with the sub-counts and alternatives that have been read out?
Yes, I heard them.
How do you plead to them?
I plead not guilty.
Thank you. You may be seated. Perhaps let me just record the plea of the second accused as well, Mr. Pompo, if that's in order. Mr. Roux, where's the representative from Thales? There.
Mr. Durant.
Yes. So you've heard the charges that have been put from the indictment. In respect of accused number 2, who you represent, they relate to counts 1, 3, 5, and 6, with the sub-counts and the alternatives that have been read out this morning. Likewise, as with Mr. Zuma, I take it you are aware of those charges. You've no doubt had the benefit of legal advice in regard thereto, and do you understand those charges?
I plead not guilty, my lord.
You plead not guilty to counts 1, 3, 5, and 6, and the alternatives. Thank you very much. You may be seated. Yes, thank you, Mr. Mpofu. I think we can then hear you.
Yes, my lord. Firstly, just to confirm to your lordship that the plea is in accordance with our instructions. And that, of course, as your lordship was made aware by my learned friend, Mr. Masuku, before, that plea in our case will be coupled with a plea in terms of 106 1H of the Criminal Procedure Act. As God pleases. And my lord, once Mr. Roux has confirmed his instructions, we have a short statement to read, which I will hand out a copy of.
Thank you. Formality's sake, Mr. Roux, you confirm that the plea of accused number 2 is in accordance with your instructions?
Indeed, my lord.
How do you wish to deal with the plea in terms of 106.1H? Are you satisfied just to raise it? And I'm asking this also for you, Mr. Dana. Or do you want it also to be confirmed by Mr. Zuma? Perhaps you can deal with it, and then he can just confirm it at the end.
Yes, my lord. But my lord, firstly, let me just apologize to my learned friends. We have a signed copy, which I will hand up, and we will find a way of retrieving it to make copies for our learned friends, but we will give them unsigned copies. What we propose should be done, my lord, is that we read it into the record, and your lordship can then confirm it with the first accused.
I shall do so.
I beg leave then to hand that copy up.
Thank you. And I'll give it an exhibit number in the meantime, Exhibit B.
Thank you. My lord, might I just intervene and just ask my learned friend for some clarification? So we do have an affidavit which supports the 106.1H plea, which, as the court has heard, was given to us initially in draft form and then in a final form, but it's still being worked on. What is this? Might I just ask my learned friend, what is the status of this current statement? Is it a summary of Mr. Zuma's affidavit, or does it have a different status? Because it seems that the 106.1H was being conducted in terms of affidavit, which is now going to receive an answer from the state and then a reply. So I'm just wondering what the status now is of this and why it's necessary. I mean, I can't form an opinion about whether to say yes or no until I know, and I hope there's no problem.
Yes. No, my lord, there's no problem. The two things go together. The statement that we're going to read into the record is merely a statement of the plea. So it's a combined, as the lordship can see from the heading, it's a combined 115 statement, but it also deals with the 106.1H. What we propose to do thereafter, my lord, Mr. Downer is correct, I should have mentioned it earlier, is effectively to read into the record the affidavit. And our instructions, as I said, was to read quite large parts of it, but we have reached a compromise, but we will still need some time to put it on the record, my lord. And unless there's an objection, my Lord, what I can undertake up front is that we will deliberately refrain from giving argument, so to speak. It's simply to put the statement on the record, because it would be unfair on Mr. Downer. Argument will happen on the 19th, as we have all agreed.
Yes.
But that is our proposal,
Yes.
my Lord.
I certainly would like to try and avoid a duplication of argument.
Yes, of course, my Lord.
And the affidavit is there.
Yes.
It can perhaps
And your Lordship has read it.
it can just be confirmed.
Yes. So we will, to the extent possible, really give out the highlights as per our instructions. Mr. Masuk and I have committed that it won't be too much of a painful exercise.
Yes, if it can just be kept to manageable proportions, because it's forming part of the plea. It's also a public document.
Yes.
So it is available.
Yes.
I think
So
members of the media have certainly
have access
probably had regard thereto already. So yes, I entrust to you, but let's try and keep it as
yes, my Lord, and
as
we will take
short
guidance
as we
from your
can.
Lordship, of course, if we overstep.
Yes, Mr. Dana, does that address your concerns?
As far as this section 115 plea and combined with 106, it's all in order, my Lord. I'm
Thank you.
absolutely happy. I would join the court in asking my learned friend not to prejudice us really, because we have it all on oath.
Yes.
So to have in addition a summary of the oath at this stage before those proceedings are actually really adjudicated it would seem to me to be unnecessary. But I'm certainly would rely on my learned friend to keep it short.
Well, I gather that he is going to keep it very short, and hopefully we can dispose of it on that basis.
As it pleases the court.
Yes. Yes, Exhibit D then, that's the plea explanation.
Yes, please. May I go ahead?
Yes, you may proceed, sorry.
My Lord, the statement is signed by the first accused and his legal representatives. It reads as follows, my Lord. Between the term lines, it's a plea in terms of section 115, 1061H, and 1064 of the Criminal Procedure Act. I am the first accused in this matter. I understand the charges against me and plead thereto as follows. My Lord, I will summarize the first part. Maybe let me put it...
Yes, once again, Mr. Mpofu, I think because of the magnitude of what we're dealing with,
yes.
At the end, I'll just ask Mr. Zuma to confirm the statement.
No.
And if you want to present a précis thereof, a shortened version, then certainly I would appreciate that.
Thank you, my Lord. Well, then, regarding count one, I plead not guilty to this charge of racketeering in contravention of Section 21E, read with Section 122 and 3 of POCA, as amended. I reserve my right not to disclose the basis of my defense at this stage. At count two, it's the same plea, my Lord. And then as far as the alternatives are concerned, again, it's a plea of not guilty to the two alternative counts of corruption. And we set out, I won't read out the sections, the various sections.
Yes.
And the accused again reserve his right to disclose the basis of his defense, not to disclose the right to, if your Lordship can just make that correction there. Reserve my right not to disclose the basis of my defense at this stage. And then as far as sub-count 2, same plea of not guilty, my Lord, for the charge of receiving unauthorized gratification by a person who is party to an employment relationship in contravention of Section 10, read with all the other sections that my learned friend went through. And once again, my Lord, the accused reserves his right not to disclose the basis of his defense to that charge at this stage. count 3 doesn't apply to us. As far as count 4 is concerned, it's the same plea, my lord. Plea of not guilty to that charge of corruption, which relates to section 111B, read with the other subsections. And the accused, my lord, reserves his right not to disclose the basis of his defense to that charge at this stage. As far as count 5 does not apply to us. Count 6, the same plea, my lord, to the charge of money laundering in contravention of the section 4 and the subsection, the other sections mentioned. The accused, my lord, once again reserves his right not to disclose the basis of his defense at this stage. As far as the alternative to count 6 is exactly the same plea, my lord, and reservation. And as count 7, plead not guilty to the crime of fraud for reasons that will not be disclosed at this stage. At count 8, plead not guilty to the crime of fraud for reasons that will not be disclosed at this stage. At count 9, the same plea, my lord, not guilty, and reservation. And that cluster of counts 10 to 18, my lord, the accused plead not guilty to the crime of fraud for reasons that will not be disclosed at this stage. The alternatives to 10-18, I plead not guilty to the charge of contravention of 104.1, read with the other sections. And once again, it's stated, I reserve my right not to disclose the basis of my defense at this stage. Further alternatives to the cluster 10 to 18, same plea of not guilty, my lord, and the same reservation of rights. And then, my lord, that is as far as the charges are concerned, and that obviously confirms what the accuser has already told the court.
Right.
As far as the 106.1H, my lord, is concerned, I'm now at paragraph 14. I give notice of my intention to raise a further plea in terms of section 106.1H of the Criminal Procedure Act 1977. For that reason, for the reasons that are set out in the plea explanation, Mr. Downer should be removed as the prosecutor in this case, as he has no title to prosecute. There are facts and circumstances involving the conduct of Mr. Downer and the NPA generally relevant to the protection and interpretation of my rights under section 35(3) of the Constitution, for which it is necessary that Mr. Downer be removed as a prosecutor in the case. 15. Furthermore, there are facts and circumstances that give me a reasonable impression that Mr. Downer has conducted himself in this case in a manner that lacks the independence and impartiality that is necessary for a lawful prosecution. Examining his role in the totality of the facts and circumstances of this case, Mr. Downer has failed to uphold the standard and prosecutorial independence and impartiality needed to secure that my trial is fair and conducted in accordance with the Constitution. In any event, Mr. Downer placed himself as a witness against me when he filed an affidavit in support of the Democratic Alliance's application to review and set aside a decision by the NPA to terminate my prosecution on the basis set out in the affidavit of Mr. Hofmeyer, the National Deputy Director of Public Prosecutions, and Advocate Mshe, who had served the NPA as the Acting National Director of Public Prosecutions. His opposition to the NPA's basis for defending the termination of prosecution decision places him in a position of a prosecutor who is neither independent nor impartial in relation to my rights to a fair trial or the obligation of the state to ensure that I enjoy a fair trial. His opposition to the NPA's position that my prosecution had been exposed to unlawful political manipulation disqualifies him to prosecute me in the same trial, in that it is inimical to the constitutional requirements set out in Section 35(3) of the Constitution. 17. In the event that my plea to have Mr. Dana removed under Section 106(1)(h) of the Criminal Procedure Act 1977 is successful, I am entitled to be acquitted in terms of Section 1064 of the Criminal Procedure Act 1977 on the basis that the trial will be unfair. I set out my grounds of this plea under Section 1061 of the Criminal Procedure Act in my affidavit attached herein or hereto as JZG1, signed at Pietermaritzburg on 17 May 2021, and the signatures are as reflected in your Lordship's copy. As the court pleases.
Yes. Mr. Zuma, can I just confirm with you, please, the statement that has just been read out by your counsel, do you confirm the correctness thereof?
Yes.
Sorry. There is just one paragraph. You've signed this document. In paragraph 3, the word "not" was left out. And I wonder whether I can hand this down. Mr. Mpofu, if you can please just ask Mr. Zuma just to initial next to it for the sake of regularity. For the sake of regularity, so that we have... yes. No, it's plainly just an omission, but let's just correct it. The document also expresses that I intend, I think the words was, I give notice of my intention to raise a further plea, but in fact that plea has now been raised.
Yes, my Lord. That was before the two documents were completed.
Yeah, well, because what appears from paragraph 14 onwards of that statement is in fact just a repeat, a copy of what was in the notice of the intention to raise that plea.
As your Lordship pleases, yes. So we simply married the two documents.
Yes. If it has been signed, if it could perhaps just be handed back.
I beg leave to hand it back.
Thank you. Yes, Mr. Mpofu.
As court pleases. My Lord, I'm indebted to the court. If I may borrow the lectern from my learned friend. Is it legal? My Lord, it's been pointed out to me by my learned friend, Mr. Masuku SC, that it is 11 o'clock. It may be convenient, therefore, to take a break before we deal with this. It might also help us in the condensation process.
Mr. Mpofu, may I just say that I have read the plea, the notice that was given, that was brought to me last Thursday, and I have read the affidavit of Mr. Zuma. So I'm familiar with the contents thereof. As you said, some of it contains references to cases and argument, and I certainly don't want that repeated.
Yes.
I don't want to curtail your right to tell me what the case is going to be about, but please just keep that in mind, that I have read it, and it'll probably all be ventilated, or a lot of it will be ventilated, when we return for the actual argument on the 19th of July, 2021.
My Lord,
so I don't know that it will serve all that much purpose today, because I've read it.
Yes, my Lord, we are mindful. That is why we begged really for an indulgence from the court, and we will ensure that it is not, that indulgence is not abused.
Yes. I'll make it 10 past 11, 11:25. We shall resume.
Let's go.
Very well. Court will rise.
You know I'm German, but I'm also French. And before I came to Africa, I was in France for a long time with a lot of African people in the team, in some clubs, official side also. So for me, Africa was not really a new thing. We had some friendly games also in Africa before with Girondins Bordeaux. So there was already a good contact with Africa. Discovering really Africa like a coach was in Gabon in 2010, and it was really interesting. I enjoyed this job to be an international team coach and not only a club coach. So that was for me a new thing in 2010 when I arrived in Gabon, in Libreville, to prepare the AFCON. And we hosted the AFCON in 2012. It was a wonderful start from my career in Africa.
What would you say for you makes the average African player special?
The special side of African players is, I think, a physical advantage they have to the European players, because generally the African players, you speak about Aubameyang, they are very fast and they jump high and they are very explosive. So that's interesting to have a fast game. Then also what I enjoy in Africa is that the passion of football is very big, and when the players are coming back in their country, they are so happy to see again the friends, the family, and the teammates from other clubs. Yet you have a very special atmosphere in the team, in the training sessions, a lot of fun. But I think I learned a lot in Gabon, then also in Niger, which was completely different, like very hard work in a hot weather, hot country, with people who are very motivated. And then also in Burkina Faso. My first place was Tunisia, was like a club coach in Étoile du Sahel, in Sousse. Was very interesting also. So I could see the northern part of Africa, then the West African part, and it was interesting to see the differences between them.
What are the differences though? I'm really curious. You've worked in North Africa and you've worked in West Africa.
Like you see in North Africa, you are closer to Europe and you have a smaller bridge to go there and more influence from Europe, because when you see the infrastructures, for example, they are really trying to do like they do, for example, in France, in Clairefontaine Center, where the football has a lot of pitches and halls and fitness rooms. Everything is wonderful. French team is preparing the games there. So they decided to have a look on France or on Germany from other countries and to be inspired by what they are doing and to take the good sides, especially for the infrastructures, but also for the training's quality, for the program of a year, and also even the clubs. I think they play a lot of friendlies with European teams, so it's easier for them. West Africa is far away from Europe, and it's more difficult to have the same good grass and the same good stadiums like they have in Northern Africa, wonderful stadiums in Morocco, in Algeria, in Tunisia. So they have this little advantage before West Africa.
The great Pele came to Africa during the African Nations Cup in 1994. Nigeria won that Nations Cup between Zambia in the final. And he made a prediction and said before the end of the 21st century, an African team would win the World Cup. It's almost 24 years after now, and it still doesn't look like an African team maybe has the chance to win the World Cup. Has it been that African football hasn't really developed in 24 years, or the rest of the world just hasn't stood still?
It means that we are not ready yet in Africa to win the World Cup for several reasons. The first reason for me is the organization, general organization. Still a lot of problems for traveling, for preparation, for also the preparation of the game specifically. Like here we will play in Lagos, 10 years, no match of the Super Eagles here, so we know that there is no tradition here. France is world champion for the moment.
France are the champions of the world!
Where they are playing? They are playing in Paris Saint-Germain, they are playing in Bayern Munich, 4 of them. They are world champion of the clubs also. The Tolisso, the Pavard, he even scored the goal in the final for them. The Lucas Hernandez, Coman, they are all playing there. And when you have so many players from your country playing in the best clubs, so the probability that you have also one of the best teams in the world is very big. So what we have in Nigeria, for example, speaking about our country, we have our players in Fulham, in West Bromwich. It's not Bayern Munich, it's not Paris Saint-Germain, it's not Liverpool, it's not Manchester City, it's not Barcelona, it's not Real Madrid, but the other one, they have their players there. So it would be a miracle if actually we could win a World Cup.
So were you saying now that even though we've got likes of Sadio Mane and Mohamed Salah playing at top clubs, just having just a few sprinkle of players at big clubs won't be enough to get the quality to win the World Cup?
It's not enough to have a few players. You need at least 15 or 20 players, and the French players are at least 30 in big clubs everywhere. So it's easier to choose the high quality than if you only have Ndidi and Iheanacho in Leicester. It's a good club also, but the biggest club is that for our players. We don't have any more in Chelsea like before, it's finished. I think we have to wait for this moment to prepare our players that they can play in the biggest club, because the work is done all year long in the biggest clubs, not in the 2 weeks we have them together.
When players spend the bulk of their time at their club side, and then you have to bring players who play different styles at different clubs, you have to bring them together, and especially when you coach teams like Nigeria, Cameroon, the Ivory Coast, fans generally in those countries think that you can put them all together and you must get them to play beautiful football. How do you cope with that expectation?
It's not easy because the time is so short that you have sometimes only 2 or 3 training sessions to prepare the match. They are coming, especially now in winter time, from Europe, in the hot weather from November to March, especially in this time they come, they have this difference. They have also the problem to find back our style of football and to find again the complicity with the teammates. Much more easier in a club when you are together every day all long. What we have when it's AFCON time, we were together 7 weeks, World Cup 7-8 weeks with the preparation. Then we have the time really to become a team and to know each other very well. And that's why it's very difficult for new players who are invited sometimes to find immediately the complicity with the team and the harmony.
That's another question Nigerian fans are always asking. They say Gelo Oroa has invited new players, but the Super Eagles play matches and he invites the players but doesn't give them a chance to play.
Yes, we have, I think we tried in the last few friendlies and even in the international games in Benin City and in Freetown. We had some new players. We had some players who decided to come with us, leaving, for example, Germany, the under-20, under-23 for Akpoguma, and deciding to come with us. It's fantastic, but they need little time to come in. And it's not easy in a few training sessions only to find exactly the right way to play with the team. It's more easier for the other one who were with us in the World Cup and who played with us in the AFCON bronze medal game, for example. But we have to try to invite better players. Friendlies are good for that, to see them. That's what we did against Tunisia, Algeria. When they are friendlies, it's not for the result we are playing. We want to see new faces. We tried new goalkeepers. We tried new wingers. We tried a new defender and a midfielder, Onyeka from Midtjylland, Jakuba, the goalkeeper, Austrian goalkeeper. We saw a lot of players in the friendlies, but they are not enough. We only had 2 since 1 year. So when you have the games, when you have to do the result, it's not the best moment for the players and for the team to invite the new one.
How do you cope with backlash from fans in Nigeria? Because when the team is winning, everything looks good. When the team starts to stutter and not win matches, how does Gernot Rohr react when you see some of the posts on social media about whether Gernot Rohr isn't doing enough, Gernot Rohr hasn't improved the team, or how do you cope with that?
I don't go in the social medias already, and
That's on purpose.
critics are normal everywhere. We are used to it. You know, it's a few years already that I'm a coach. For the long time, I was 17 years long a player, professional player. I had a long career. I saw everything, I think, everything what you can imagine in my football life, like a coach, like a player, and so I'm not surprised. I want to protect my players, and it's even better that the coach is taking all the critics and I can protect the players. We didn't lose, we made draws. Okay, I'm responsible for the results, but please don't attack the players. The players are coming from Europe. Sometimes they are injured. Osimhen is coming back with the shoulder injured, broken, to Napoli, 3 months without game. They are punished. They don't earn any bonuses in the clubs because they are not playing, because they came to Nigeria and they had injuries. And so, you know, I want to protect my players. I want them to come with pleasure and with a big motivation. So it's good they can critique the coach. It's normal. Everybody is a coach here in Nigeria.
We've seen a lot of African players come from Africa and go to Europe, but only recently Mbaye Laye, the former Senegalese international, got appointed as the manager for Standard Liège in Europe. Yaya Toure, Radi Jaidi got some assistant coaching roles in Europe. And there's been a lot of talk around Pitso Mosimane, the former South Africa coach who currently coaches Al Ahly. And there's something of a revolution saying that Africa is starting to produce top-class coaches who can start on the continent and go abroad. In your capacity as a coach, you have worked on the African continent and you've worked with local assistants. Do you think that African coaches have what it takes to make the step up and leave Africa and coach European sides?
I think they can. They're doing it. And so there's no reason that African coaches cannot succeed. They will come, they will succeed. I worked here in Nigeria with good local coaches. I had diplomas, of course, because you need a coaching school. You have to do with CAF Confederation also some campings and some experiences, and they're working on it, I think, in the CAF to have a better
And there seemed to be some misunderstanding as to which part of the Constitution is being invoked here. The right to a fair trial, my lord, has got absolutely nothing to do with the merits or demerits of the case. It is simply a right that the framers of the Constitution decided to give to all of us. And like any right, it doesn't matter whether it's the right to life or the right to a fair trial, it must be respected by the state. Now, we say from paragraph 8, in order to appreciate the basis of the plea, in other words, the 1061H, the following facts are relevant and will be amplified further in the affidavit. A careful analysis of Mr. Downer's SC's role and attitude over the period of this case, and in relation to whether I should be prosecuted, discloses facts and circumstances that make him an essential witness in relation to an important aspect of my right to a fair trial. It relates to whether my fair trial rights guaranteed in Section 35 of the Constitution have been vitiated by incontrovertible evidence of political and intelligence interference and manipulation in the decisions involving the DSO's investigation against me and the NPA's prosecution. The evidence of political and intelligence interference in my prosecution is considered by the NPA and was the basis on which Advocate Mshe terminated my prosecution. I attach copies of the affidavits filed by the NPA in the application of the DA, in which the NPA's decision to terminate my prosecution was reviewed and set aside. In that DA's application, Mr. Downer, SC, placed evidence before the court to support the DA and the relief that it sought. Given that his affidavit was filed against the NPA, he placed himself in a position in which I could not reasonably believe in his impartiality and independence to prosecute my case fairly. This is so because he was acutely aware that the applicant seeking the termination of the decision of the NPA was a political party that is entirely hostile towards me and has utilized litigation in the matter involving my prosecution as a political campaign to have me prosecuted at all costs. Supporting a political party's application to have me prosecuted after the NPA had terminated the decision to do so creates a reasonable belief that he is not impartial and independent in relation to the question of whether political and unlawful intelligence involvement in my prosecution vitiates my fair trial rights guaranteed in Section 35. Mr. Downer's dispute with the NPA over whether political and unlawful intelligence interference in my prosecution justified a termination of my prosecution creates a conflict of interest, the nature of which breached the requirements of independence and impartiality as set out in numerous statutes and which will be referred to further below. We won't refer to those statutes. In essence, Mr. Downer SC tolerated political and unlawful intelligence interference in my prosecution with the result that he breached Section 13A of the United Nations Guidelines on the Role of Prosecutors, which requires prosecutors to carry out their functions impartially and avoid all political discrimination. In truth, the current charges which he has been intimately involved in formulating are as a result of Mr. Downer SC's active participation in the political campaigns of a political party that is hostile towards me, in this case, the DA. I nurse a reasonable view that Mr. Downer's conduct, as disclosed in his own affidavit and that of McCarthy, to which reference will be extensively made, demonstrate that he lacks the independence and impartiality to conduct a lawful prosecution. I further attach a copy of the affidavit of Mr. Downer, I also attached Mr. Downer's affidavit filed on behalf of the NPA in the permanent stay application. What is clear about that affidavit is that on the issue of political interference, it completely contradicts that of Mr. Hofmeyr and Mr. Mshe filed on behalf of the NPA. This means that there are significant disagreements in the NPA on whether or not the proven political interference set out in Mr. Hofmeyr's affidavit violated my fair trial rights. Mr. Downer SC belongs to the group of people in the NPA that believe that political interference in a prosecution should be tolerated or even accepted, while Mr. Hofmeyr and Mr. Mshe belong to the group in the NPA who believe that there should be no room for political interference in a prosecutor's decision to prosecute. My apprehension is that Mr. Downer's SC's position on political interference is wrong and disqualifies him as the prosecutor of this case on the ground that he lacks the independence and impartiality necessary to conduct my case lawfully. In this trial, Mr. Downer SC will be seeking to vindicate his view that the unlawful political interference in my prosecution had no impact on my fair trial rights. That, I am advised, is entirely unacceptable under our Constitution, as tolerance for political interference is tolerance for unlawful conduct. If prosecutors tolerate unlawful political interference in prosecution decisions, the prosecution system would be corrupted, as it would be stripped of the requirement of independence and impartiality. The evidence of Mr. Hofmeyr and Mr. Mshe that there was unlawful political interference in my prosecution will be tested against that of Mr. Downer SC, that there was no such political interference. That means that Mr. Downer SC's view that there was no unlawful political prosecution vitiating my fair trial rights as described by Hofmeyr and Mshe will be the subject of my trial. More importantly, though, Mr. Downer SC is, as has always been aware, that the despicable and unlawful political interference in decisions involving my prosecution has failed to report this conduct to preserve the integrity of the prosecution process. This is a requirement under Section 32(2) of the NPA Act. The failure to hold those who are known to him and the NPA to have engaged in unlawful interference with my prosecution demonstrates his lack of appreciation of his duty to ensure that I am prosecuted in accordance with the requirements of independence and impartiality. I therefore nurse a reasonable apprehension that Mr. Downer SC has lost his independence and impartiality to conduct my trial fairly against, and believe that he would not present evidence of unlawful political interference in a manner that is balanced if this would hurt his unwavering stance that I should be found guilty of the charges against me. Mr. Downer's denial that evidence of political interference which is admitted by the NPA demonstrates that he cannot be trusted to be an impartial and independent prosecutor, to act in good faith, which would include disclosing to the court evidence of unlawful political interference within his knowledge that could hurt the state's case against me. He has been, in my view, by failing to report admitted evidence of unlawful political interference in my prosecution, violated the oath of affirmation of prosecutors as described in Section 32 of the NPA Act. In addition, Clause 24 of the United Nations Guidelines on the Role of Prosecutors places a positive duty on Mr. Downer to report violations on prosecutorial guidelines to authorities for action, which he has not done in this case. Such failure to report and act on unlawful interference in the prosecution processes involving my case is in itself a specified offense, or offense in terms of Section 11 of the NPA Act, as amended by Act 61 of 2000. Then we come to the second issue, my Lord, in terms of if the broad issues, the first one is the DA supporting affidavit. The second important topic, my Lord, is the issue of media leaks about my prosecution. The NPA has condemned the extensive media leaks that were entirely damaging of my fair trial rights, as they exposed me to unprecedented public attacks, resulting in a public narrative that I'm guilty of the allegations. I am aware of Mr. Downer SC's intimate engagement with journalists from the transcripts of telephone records in which Mr. Downer SC held meetings with investigative journalists who were writing very prejudicial articles about me. I attach a copy of the transcript showing Mr. Downer SC making arrangements to meet Sam Soul of the Mail and Guardian in JGZ4. The full extent of his interaction with a journalist who churned out very damaging and defamatory stories about my prosecution is still unknown. This conduct was not properly investigated, as no one appears to have been held liable for these damaging media leaks. There is prima facie evidence based on these transcripts of recorded conversations between Mr. Downer and Mr. Sam Soul, which give me an inescapable impression that Mr. Downer SC gave Sam Soul information for some of the articles that he wrote. This conduct would be a contravention of Section 41(6) of A of the NPA Act, in that it amounts to unlawfully disclosing information to another person that came to his knowledge in the performance of his functions in terms of Act 32 of 1998. Or it is a contravention of 41(6)(c), in that it amounts to unlawfully disclosing to an unauthorized person the record of evidence given at an investigation, as contemplated in Section 28. This conduct is, in addition, a contravention of Section 13 of the United Nations Guidelines on the Role of Prosecutors, which places a positive duty on prosecutors to act with confidentiality. So that breach of confidentiality then covers the second topic. In fact, in the report prepared by Justice Gampepe on the DSO, she made the following findings about media leaks, which I believe Mr. Downer was also involved in. In paragraph 21(2) of the Gampepe report, she found that the, quote, improper media sensation associated with the investigation and or arrest of some individuals resulting from the leaks in the DSO may open a practice that is inconsistent with the right to a fair trial guaranteed under Section 35 of the Constitution. Taken cumulatively, therefore, there is prima facie evidence that offences contemplated in Section 41 of the NPA Act were committed, which Mr. Downer SC and the NPA must be held accountable for. Mr. Downer's immediate and long-term reaction to Mr. Mshe's decision to terminate my prosecution is a telling indication that he lacks the requisite independence and impartiality necessary to prosecute me. And my Lord, without, as I promised doing editorial at this stage, I would add that this section deals more with also the requirement of a prosecutor having to be dispassionate, or a dispassionate player. I am informed that Mr. Downer SC states in his own affidavit in the case of the DA that he cried when Mr. Mshe made that announcement and threatened to resign in protest against that decision. His emotional reaction to a decision to terminate a prosecution on the basis of proven unlawful political interference in the prosecution demonstrates an individual who has gone beyond the acceptable level of intrinsic partisan bias in adversarial litigation to an extreme obsessive point, such that he now lacks the requisite steadiness and objectivity that is required to prosecute a trial fairly and without a single-minded pursuit of a conviction. Therefore, there is, in my view, no escaping the conclusion that Mr. Downer SC has wittingly or unwittingly turned the prosecution into a personal legacy project of his own rather than a pursuit of justice based on an independent and impartial mind. His public engagement, in which he has freely given strong views about my prosecution, has no doubt been part of what has galvanized the political campaigns for my prosecution, irrespective of the clear unacceptable violations. His dismissive attitude towards the findings of the prosecutor's report by Advocate Mushwana, which found that Mr. Ngcuka, the NDPP, and the NDPP had violated my, or rather, who was then the NDPP, had violated my rights when he held his famous press conference, tells many tales about his sensitivity to my constitutionally enshrined rights. That report of the public protector has never been challenged by the NPA, except when Mr. Downer SC filed his affidavit in the permanent stay application. How can an independent and impartial prosecutor with a title to prosecute persist with a prosecution in circumstances where there is incontrovertible evidence that my constitutional rights relevant to a fair trial were violated? For completeness, I attach the public protector's report. That is Mr. Downer SC, has championed my prosecution with unrestrained gusto to ensure that I am convicted at all costs, despite evidence and findings of credible constitutional bodies that my right to dignity has been violated by the NPA and Mr. Ngcuka. He is then head of the NPA. To the knowledge of Mr. Downer SC, the remedial actions of the public protector in paragraph 25 were never implemented. The public protector issued a binding remedial action in terms of which the NDPP and the NPA were held accountable by virtue of the provisions of section 41.1 and 181.3 of the Constitution and section 35 of the NPA Act. Failing to cooperate with the public protector in the investigation of the complaint of the Deputy President, infringing upon the Deputy President's constitutional rights to human dignity and thereby causing him to be prejudiced, and C, acting in an unfair and improper manner in regard to the Deputy President, as the first accused then was. None of these binding orders of the public protector were implemented to the knowledge of Mr. Downer SC. Like Justice Khampempe in her report, the public protector also found that there was a need to restrain the abuse in the DSO's abusive manner in determining policy guidelines in respect of the functioning of the DSO that would prevent a recurrence of the improprieties referred to in the report. Needless to say, Mr. Downer SC ignores the binding findings of the public protector. I believe his attitude towards pertinent matters relating to my rights to a fair trial should disqualify him from prosecuting this case. He simply does not have a lawful title to prosecute me by virtue of being impartial and lacking in independence. Again, if I may just pause for 1 second there, my Lord, to emphasize the word disqualify, because that is really at the heart of this plea, that a person is disqualified. So the issue of the title is not merely, the title because you have an LLB or you signed a particular certificate. You can be disqualified in the broader sense of the word by your conduct. His denial that the NPA's decision to prosecute Sheikh alone in circumstances where I was implicated resulted in a failure of justice, in that I was effectively convicted in absentia in the case of Sheikh, which demonstrates a lack of impartiality. My right to equality and to the equal protection of the law was violated when Mr. Downer SC presented evidence in the trial of Sheikh that resulted in adverse findings by Judge Squires against me. I believe that Mr. Downer SC's strategy to prosecute Mr. Sheikh alone was intended as a trial run against me, in that it was designed to bolster his chances of successfully prosecuting me. He says so in his memorandum, on which I should be charged, addressed to Mr. Bikoli after the Sheikh conviction. I attach a copy thereof as JG Z6. For all the reasons set out above, it is clear that Mr. Downer SC should be removed as prosecutor in my case. He has neither the independence nor the impartiality of a prosecutor required to conduct a lawful prosecution in terms of the law. I have a reasonable apprehension that his prosecution of this case will impact on my constitutional rights and result in an unfair trial. Negatively impact, I may add. Yes. I am concerned that Mr. Downer's relentless pursuit of the prosecution is not aimed at finding the truth, but to bolster his political narrative of a corrupt leader of the ANC and president. I have now been advised of very damaging information relating to how Mr. McCarthy, his immediate head, was in regular contact with the intelligence operatives in foreign governments, in which he freely discussed my prosecutions with them. I want to set out this aspect carefully because, if true, then Mr. Downer has also been involved in a serious scandal in which my prosecution has been subject of special interest by foreign intelligence agencies, a serious contravention of the law indeed.
Mr. Mpofu, I understood from paragraph 9,
yes,
that you've just quoted, for all the reasons set out above,
yes,
that really encapsulates paragraph 8.
That encapsulates
and the 3 points that you mentioned.
As God
encapsulates the basis for this plea,
yes,
in terms of section 106(1)H.
As God
and what follows thereafter is largely just amplifying or sketching a broader background, yes, to this.
Yeah,
that we can perhaps best deal with when argument is addressed on the 19th
yes,
July.
My Lord, your Lordship is quite correct. The three pillars, if you like, would be the DA affidavit, the connivance with journalists, and then this issue, the third one, of the intelligence services. So your Lordship is quite correct. The rest of the affidavit does qualify it. But if your Lordship would indulge us, I would like maybe Mr. Masuku just to summarize a section that is further on. So I'm quite happy with your Lordship indicating that as far as we had intended to go up to about page 28, but your Lordship is quite correct that that section is amplification.
I think,
yeah.
Sorry?
No, my Lord.
I think the basis, the purpose of the present address is to disclose the basis of the defence.
Yes,
and I think you've done that.
That's correct,
in broad terms.
That's correct,
and probably no more is required than what you've done.
Yes.
It's obviously a version. It might be contradicted when affidavits are exchanged in the fullness of time. We'll have to wait for that.
Yes,
but I understand the basis now of the plea.
Of the plea. Yes, my Lord. And we see it as part of the 106. It's really expanding on the 106 explanation of plea,
yes,
at this stage. So I'm in your Lordship's hands.
Yes, I think that what is the purpose of you addressing me has been fulfilled, because I know what the basis is now.
That's good. If I can just confirm.
Certainly.
My Lord, we don't want to have this toing and froing here. Could we ask Your Lordship's indulgence that we go to talk to Your Lordship in chambers, and then we'll hopefully resolve the rest of the day?
Well, I think there's a lot of public interest in the matter, so let's deal with it.
Okay.
An open court, I think.
Okay.
That's better.
Yes. Okay. Then, my Lord,
I like the process to be entirely transparent. No. I'm not suggesting that anything not transparent would result, but I think it's better that we deal with it in open court.
I agree with Your Lordship entirely.
Well.
In this type of trial, my Lord, that is essential.
Yeah.
Well, then, my Lord, if as I said, I'm in Your Lordship's hands, but my instructions are quite firmly to at least have one small section that Mr. Masuku would deal with, and then we would wrap it up.
Well, if there's something that he needs to deal with, and it's going to contribute to my understanding of what the adjudication of the plea in terms of 106(1)(h) will entail, then I welcome it. But if it's just a repetition of allegations in the affidavit, then there will be a time.
Yes.
When that will be fully canvassed, yes, if it's relevant to the issue.
No, we accept that, my Lord. Yes. We are indebted to Your Lordship.
Thank you, Mr.
As a court, please. I'll then hand over to my learned friend, Mr. Masuku SC.
Yes. Just give me a moment, sorry. Yes. Yes. I've just been advised by by my registrar and the stenographer. There are some cell phones that are on, obviously on silent, and if they are close to the recording equipment, they are causing an interference. So please, cell phones off preferably, or then far removed from recording equipment, please. Otherwise, it will affect the record. Yes, Mr. Masuku.
My Lord, I dread to do this because of the warning you have given, and while grateful that you understand the basis of the plea, you also make a very important point that this is in fact a very important event for the accused, to not just tell you, but to tell the public what has happened to him. So it's important that you bear with us for maybe 30 minutes. If after 30 minutes I don't satisfy the standard you are looking for, please, I'm happy for you to then reiterate what you said to my learned friend about appreciating the basis of the plea, because that's very important that you understand the basis of the plea, my Lord. But it's also important that the accused person is able to be given the moment he needs to explain in a plea, as is done here, for the public. The most important thing being that his complaint about unfair trial rights is that there was political and intelligence interference. Because he is a political leader, he has a significant constituency of people who must understand why he is here, why he believes he's here. And so I would urge Your Lordship to bear with us. We appreciate the time constraints, and I will be absolutely sensitive as the accused has been, that you've said you understand the basis of the plea, and we do not wish to to do more than we intend to do with this. So 30 minutes, my Lord, all I ask for is that you give me 30 minutes to say what I have to say, even if it means that some of the things I say are a repetition of what my learned friend has read.
Yes, Mr. Masuku.
30 minutes.
Yes, no. Can I just comment briefly on what you've said?
Thank you.
My statement that I made was not intended, and certainly isn't a warning.
Oh, I appreciate that.
And no, perhaps just a choice of words, but it's not a warning. I'm not cautioning anybody. I was simply expressing my understanding of what had been conveyed from the bar.
My Lord, I misunderstood.
No, not at all. These things happen in language. Secondly, the purpose at the moment is for you to disclose the basis of the defense. That's the legal basis. I can appreciate that it's tied up with some political considerations, but this is not the opportunity for an accused person to state his version. It's not evidence. This is an affidavit. His evidence is contained in the affidavit. The evidence as contained in the affidavit will be adjudicated upon when the point is argued. If you feel that there's something that needs to be disclosed to improve my understanding and everybody's understanding here as to what the basis of the defense is, then please disclose it. But please just keep that in mind, not as a warning, but as what I consider to be the permissible limits of an address dealing with the disclosure of a defense or the basis for a defense. I think we're on the same page on that, and I can just implore you to keep those considerations in mind, please.
Yes. My Lord,
yes,
then
please continue.
Perhaps just to wrap up from what my learned friend has read, you will see that on page 16, there is a paragraph that deals with involvement of foreign intelligence agencies in the NPA. I will not read that paragraph, but I will read the paragraph that comes on paragraph 14. Mr. Downer SC is acutely aware of McCarthy's intelligence connections. When Mr. Downer became aware that Mr. McCarthy was engaged in conversations and receiving gifts from CIA agent Andre Pinar, codenamed Luciano, he was obliged by law and his duties as a prosecutor to have the matter investigated and appropriate action taken. His failure to do so could also constitute a criminal offense. It is doubtful that McCarthy's investigations were lawfully authorized. This goes to the heart of whether it is correct for Mr. Downer to seriously contend that he is the right person to present evidence against me that was potentially obtained unlawfully. Mr. Downer SC and the NPA are fully aware of the damage caused to a lawful investigation involving me, but decided to ignore this because, according to Mr. Downer, whatever Mr. McCarthy did had no effect on the lawfulness of the prosecution. I want to know and to hear from Mr. McCarthy if he was lawfully authorized to sanction intelligence operations against me to gather information that Mr. Downer would use against me. I want to know who authorized him to conduct intelligence operations against me. I want to know who are the foreign intelligence agencies that unlawfully helped McCarthy with evidence against me. I wish to point out that following his unlawful actions in relation to investigations involving me, McCarthy had to leave South Africa to possibly avoid being prosecuted for his criminal activities, which, in my view, are being covered up. It is a matter of public that Mr. McCarthy, who has caused untold damage to me, was rewarded by his friend, who offered him a position first with Knoll Incorporated in France, a known CIA front company. He opted to take a job at the World Bank, which is also offered by Andre Pinar. My Lord, perhaps I should then jump.
That's really just an example of the third leg that Mr. Mpofu referred to.
It's fair enough.
Yeah.
Maybe I have a view on it, but maybe just to use my time properly, can I then read something else that I believe is a further leg of what would enhance your...
If it will improve my understanding or everybody's understanding of the basis of the plea, then by all means refer to it. But if it just is an example, a factual allegation to support or establish one of the three legs that I think Mr. Mpofu has clearly and succinctly identified, then it seems to not add much to the debate for present purposes. It'll be dealt with in the argument.
Perhaps the biggest difficulty, my Lord, with what proposition you're putting to me is that I don't know how much you know of the how much to give you, because I wish I knew exactly the extent of your knowledge of what is in here.
Now you can accept, as I indicated earlier on, that I've read this affidavit, and I can also mention to you that when the other volumes are going to be indexed and paginated, you don't have to take this volume 1, away. I will index and paginate it because I've already referenced it and cross-referenced it and made my own notes, which are confidential and privileged to me. So I've done quite a bit of work on this, Mr. Masuku. So you can accept I'm not infallible. Maybe I miss a point, and I'm sure it will be highlighted when argument is addressed in July. But for present purposes, I would like to think I've got a fairly good working sort of basis of what's in the affidavit.
My Lord, might I interrupt at this stage if my letter says leave? I don't wish to interrupt.
I think just leave it for the moment, Mr. Dana. These are allegations that are made. I know you're going to deal with them later, but let's just deal with the...
As it pleases the Court.
This is an address on the basis of the defence, and I'm prepared to listen to that. Certainly.
My Lord, further on, we deal with the fact that Mr. Downer ignored, did nothing when his advice to the NDPPs to charge Mr. Zuma were ignored. You will see that it starts from paragraph 80. And you will see there...
80?
Sorry, page 80.
Page 80.
80, paragraph 165. You'll see we deal with that, with his advice, which was consistent, was given to Mr. Nguga. Mr. Nguga charged Mr. Zuma together with Sheikh. His advice was ignored. We also deal with what advice he gave to Mr. Mkodedi.
Mr. Masuka, I think what you're doing now is possibly quite helpful. Refer me to the page and particular paragraph numbers that you want to emphasize, and I can read them at my leisure when I have time.
Yes, that's how I thought maybe that
page 80, paragraph 165.
No, so I mean, you could read from paragraph 165 up until paragraph 168.
Yes.
Which is really the fact that the advice he gave to Mr. Nguga to charge was ignored. And he basically said, don't get into politics, just charge him. And that's the advice he also gave to Mshe. And he was very upset about the fact that Mshe had decided to terminate the proceedings. My Lord, you could have regards to paragraph 172, 173, 174, 175. That's roughly a summary of what I would say comes from Mr. Downer's own assessment of Mr. Mshe's evidence and how he characterized that particular evidence. You will see, my Lord, in paragraph page 89, paragraph 180.4, in paragraph 7 of a memorandum that Mr. Downer had given to one of the NDPPs, that affidavit is referred to. Sorry, that memorandum is already been referred to in previous pages, but you will see there he says, in every single instance where the incumbent NDPP has acted contrary to our advice, the results have been damaging to the case of the NPA. It seems, however, that the lesson has not yet been learnt, that it is inadvisable for the prosecution to dabble in matters of politics, even while the best possible intentions. We fear that this instance will be no different. So, in his own words, there was a damaging political interference. You'll see all those pages, those paragraphs, my Lord, are relevant for our thing. And then paragraph 185, which is on page 92. He says, in respect the so-called spy tapes, Downer says that there was a general agreement that their contentions were shocking. If authentic, they cast serious doubt on McCarthy's integrity. Nevertheless, the prosecution team remained convinced that the prosecution should continue. In a memorandum dated 20 March 2009, Downer advised the NPA to ignore the tapes and proceed with the prosecution of Mr. Zuma. You'll also see page 95, paragraph 192. This is what Mr. Downer, he went out publicly and addressed public forums together with a colleague of ours, Mr. Trenkov, and they had some very damaging things to say about the prosecution's decision to terminate the prosecution of Mr. Zuma. So if you read there, you'll see that his public utterances were not different to that of a political party, the DA, that he subsequently filed an affidavit in favor of. So you'd see there in paragraph 192, 93, and 194 and 195, we say in 195, this mobilization of society against the termination of my prosecution was particularly painful for me because I remained trapped in the allegations of corruption. In essence, even though I disagreed with Turnkov SC on his assessment of the case, I was concerned that he regarded the termination of prosecution as a threat to our constitutional democracy, the very allegations that I am now being accused of in the Zondo Commission. The point, however, is that it is clear that the NPS conduct in refusing to heed Downer's advice to charge me has never been sufficiently explained to me. And then, my Lord, I will not refer to what Mshe and Hofmeyer's affidavits say about the termination of the prosecution itself, but in simple, they say it would result in an unfair trial, something that Mr. Downer disagrees with most profoundly, and was successful in having that looked at by the Supreme Court of Appeal. My Lord, we then look at what the courts have said about the NPA's conduct in different courts. We will go through those judgments. You will see that where the NPA failed to prosecute, they were criticized by the courts. Where they terminated prosecution, they were criticized by the courts. What do we have now? We have a prosecution, in essence, that seeks, in which Mr. Downer would be essentially seeking to vindicate his own position which was taken within the NPA. In conclusion, on page 138, my Lord.
138.
In page 138,
yes.
Paragraph 292. I would like to read that into the record. Downer is aware that there is credible and admitted evidence from senior officials of the NPA that believe that my prosecution cannot be fair because of the unlawful and criminal conduct of NPA officials who interfered with the integrity of the prosecution for political and intelligence reasons. In the context of facts disclosed in this affidavit and those filed in the permanent stay application, to which reference will be made at the hearing of this matter, it is clear that Downer should be removed from being a prosecutor in terms of Section 106(1)(h) of the Criminal Procedure Act. He has no title to conduct a lawful prosecution because he lacks the attributes necessary for a fair trial, independence, and impartiality. In the event that Downer SC is removed, I'm entitled to be acquitted in terms of Section 106(4) of the Criminal Procedure Act because my trial cannot be conducted fairly in accordance with the Constitution under the circumstances. For all the reasons set above, Mr. Downer's lack of independence and impartiality to conduct a fair trial is terminal and therefore incurable. He should be removed. His passionate pursuit of this prosecution in the circumstances set out is demonstrative of prosecutorial bias in which the only objective is to win. In the circumstances, I pray for an order removing Mr. Downer, SC, of the NPA as the prosecutor in my case for lack of independence and impartiality. In addition, Mr. Downer lacks title to prosecute me because he is a witness on whether the nature of unlawful political and intelligence interference in my prosecution undermines my fair trial rights guaranteed in Section 35(3) of the Constitution. A considerable issue in my trial will be about the NPS conduct, of which Mr. Downer and Mr. McCarthy are central to my complaint of fair trial. The rest of the affidavit may be taken as read into the record, Madam.
Thank you. It's an affidavit, it's been filed, so I take it at face value, yes.
Thank you, my Lord.
Does that conclude your address?
Sir. Yes, it does, my Lord. My Lord, I have to say this. We're indebted to your Lordship. We do understand the constraints of time, but we're indebted that your Lordship appreciates the importance of this moment in this
yes, no, I do not want to limit any submission that is sought to be made that is relevant and that is helpful at this stage of the inquiry or at this stage of the proceedings. But it seems to me that you've very aptly, as I said earlier on, identified the three pillars, and I'm aware of the various factual allegations that are made in support thereof. And no doubt they'll be spelt out to me even more clearly on the heads of argument to be filed in due course.
As the court pleases, my Lord.
Yes.
Thank you, my
Thank you.
Also indebted to our learned friends for their
Yes.
patience.
Mr. Roux, can we deal with the position of accused number 2 then, please?
Thank you, my Lord. We will hand up to you, I think it's Exhibit E now, my Lord. signed,
the Exhibit E, yes.
the signed plea explanation. And may I just preface it by saying that it is not intended to be a compendium of all the disputes. We understand what it's meant for, and of course,
Yes.
many of the disputes will only be raised and dealt with in a trial. May I ask Ms. Jackson to read it into the record? It's only
Certainly.
12 pages.
I just need a broad disclosure of the basis of the defense.
That's what we tried, just to give a broad disclosure so that it would lead the prosecutor into some pattern of thinking there.
Very well. Thank you.
Thank you, my lord.
Yes,
As the court pleases, my lord, this is the second accused plea explanation in terms of section 115 of the Criminal Procedure Act.
sorry, I have, it's Exhibit E. If we
As
can
the
just
court
formally
pleases, my lord.
record that. Yes, Ms. Jackson, you may proceed.
It reads, my lord, I, the undersigned Pierre-Marie Durand, states as follows. I am the authorized representative of the second accused. I am authorized by the second accused to make this plea explanation on behalf of the second accused. Count 1, racketeering. In count 1, it is alleged that the second accused committed a racketeering offence in contravention of section 2, subsection 1, subsection E of the Prevention of Organised Crime Act 121 of 1998, POCA. The state alleges that for purposes of the racketeering count, Nkobi Investments Pty Limited, referred to as Nkobi, was an enterprise within the meaning of section 1.1 of POCA. The alleged general corruption as racketeering acts. It is alleged by the state that Sheikh, as the driving force behind Nkobi, rendered services and made payments, referred to as benefits, to or on behalf of the first accused. These payments were allegedly made over the period 25 October 1995 to 1 July 2005 and are referred to by the state as so-called scheduled payments. It is alleged by the state that the payments constituted a general retainer which allowed the alleged enterprise to exploit the first accused's political position for the benefit of inter alia Sheikh and the second accused. In order to contravene section 2(1)(e) of POCA, any person alleged to be associated with the enterprise must conduct or participate directly or indirectly in the enterprise through a pattern of racketeering. It is denied that the second accused was aware of the alleged enterprise and its activities and participated in the alleged enterprise. It is denied that the second accused was even aware of the alleged benefits and payments by Sheikh to or on behalf of the first accused. As there was no evidence in the police docket showing that the second accused was aware of, let alone participated in, the alleged payments, the second accused addressed several letters to the state requesting disclosure of all the statements and or documents showing that the second accused was at least aware of the alleged payments. The state was unable to identify any such statements and or documents. These letters will be made available to the court during the trial. It also appears from the indictment that the state alleges that the first accused intervened on 2 occasions on behalf of Sheikh/Nkobi because of the so-called general retainer, which interventions allegedly benefited Sheikh/Nkobi. It is denied that these alleged interventions delivered any benefit to the second accused. The first alleged intervention. The first intervention was allegedly on 2 July 1998. In this regard, it is alleged that Thompson required the first accused's approval of African Defence Systems Pty Limited, ADS, as its partner. Sheikh required the first accused's approval of Nkobi as its partner in order to cause Thompson to reverse its decision to exclude Nkobi from the acquisition of ADS. And the first accused indicated that he approved of Nkobi as a suitable partner, and it was decided in principle to reverse the earlier Thompson decision to exclude it from ADS. It is denied that the alleged first intervention was for the first accused to approve Nkobi as a BE partner in ADS, resulted in Nkobi becoming the acceptable BE partner in ADS, and that it caused the reversal of Thompson's alleged decision to exclude Nkobi from the ADS acquisition. In order to become a successful bidder in relation to the tender issued, a bidder needed to have a qualifying BEE partner. No formal guidance was available as to what constituted a qualifying BEE partner. BEE requirements were not legislated at the time. Thomson CSF International France, referred to as Thales International, considered a number of possible BEE partners and met with a number of high-ranking politicians, including the first accused. in an effort to identify a qualifying BEE partner or to consider the qualifications of a BEE person/entity. During this process, it emerged that Nkobi did not enjoy universal support as a qualifying BEE entity and that the concerns might have come from the then Deputy President Mbeki. It was denied by then Deputy President Mbeki that he raised any such concern, and at a meeting with the first accused on 2 July 1998, he confirmed the view expressed by then Deputy President Mbeki that there was no impediment against the BEE credentials of Sheikh/Nkobi. The process to decide on an appropriate BEE partner in ADS continued long after 2 July 1998, up until September 1999. In September 1999, it was decided that Futuristic Business Solutions, FBS, and not Nkobi would be the BEE partner/shareholder in ADS. Consequently, FBS acquired 20% of the shareholding in ADS. In terms of an agreement between Thomson CSF International Africa Limited, referred to as Thales Mauritius, and FBS, Thales Mauritius loaned the necessary amount to FBS for the acquisitions of its shares, which amount was to be repaid. It was agreed that dividends declared by ADS in due course would be paid into an escrow account to be used to redeem the loan liability. Therefore, the so-called first intervention played no role in choosing a BEE partner in ADS, other than to confirm that Nkobi was a qualifying BEE entity. In any alleged reversing of an alleged decision to exclude Nkobi from the ADS acquisition, in the share transaction between Thales International and Thales Pty Limited, which is dealt with below. The second alleged intervention. It is alleged that the first accused intervened on 18 November 1998, as a result of which an agreement was reached that Thales International would sell to Nkobi through Thales Pty Limited an effective shareholding in ADS. The reliance on the alleged second intervention is denied and contrary to the true facts and the reasons for Thales International incorporating two local entities in South Africa in 1996, namely the second accused and Thales Pty Limited. They were incorporated to pursue business opportunities in South Africa as local entities. It was never intended that Thales International would pursue business opportunities directly. Nkobi held shares in the second accused and Thales Pty Limited from their inception. ADS was identified as a likely preferred subcontractor to the German Frigate Consortium, GFC. Thales International acquired 50% plus one share in ADS. This acquisition was completed in April 1998. In February 1999, Thales International acquired the remaining shares in ADS. It was always anticipated by Thales International that in due course, the acquired shareholding in ADS would be held by one of its local entities and an appropriate BEE partner in order to give effect to the purpose of the local entities. Subsequent to Thales International's acquisition of the remaining ADS shares in September 1999, Thales International sold 80% of its shares in ADS to Thales Pty Limited and 20% of its shares in ADS to FBS, the new BEE partner in ADS. The second accused and Nkobi, as the existing shareholders in Thales Pty Limited, had to fund, in proportion to their shareholding, the purchase of ADS shares by Thales Pty Limited. This was effected by a share capital increase, which led to the issuing of new shares, 80% to the second accused and 20% to Nkobi, which shares ranked pari passu with the existing shares. The amount to be paid for the share capital increase was approximately 22.4 million by the second accused for its 80% and approximately 7.4 million by Nkobi for its 20%. Following unsuccessful attempts by Nkobi to obtain financing, Thales Mauritius agreed to loan Nkobi the amount of approximately 7.4 million, which was largely on the same terms as the loan made to FBS. As such, dividends accruing to Nkobi through dividends declared by ADS and distributed to the shareholders of Thales Pty Limited were to be paid into a separate escrow account pursuant to the agreement concluded on 30 September 1999. This meant that Nkobi would not receive dividends from ADS declared in favor of Thales Pty Limited until such time as the loan had been repaid. As such, the alleged second intervention is inconsistent with the facts, as the sale of the ADS shares to Thales Pty Limited as a local Thales entity was always envisioned. Nkobi was a shareholder in the second accused since the inception of the company. The share transaction between Thales International and Thales Pty Limited was concluded in September 1999, long after the alleged intervention on 18 November 1998. The alleged specific corruption as a racketeering act. It is also alleged that the second accused corruptly entered into an agreement with Sheikh and or the alleged enterprise and the first accused to pay a bribe to the first accused. It is denied that the second accused entered into the alleged agreement. The denial is amplified in count 5 below. The alleged money laundering as a racketeering act. It is alleged that the second accused entered into a money laundering agreement with the alleged enterprise to disguise the payment of 250,000 rand to the first accused in terms of the alleged bribe agreement. It is denied that the second accused entered into the alleged money laundering agreement. The denial is amplified in count 6 below. Count 3, corruption. Count 3 and the alternative counts thereto is the so-called general corruption count and repeats/duplicates the alleged corrupt acts relied upon as alleged racketeering acts in the racketeering count relevant to the service and or facility benefits and the scheduled payments, referred to as benefits, to or on behalf of the first accused, as well as one count of money laundering over the period 25 October 1995 to 1 July 2005. It is denied that the second accused acted in concert or actively associated itself with Sheikh and or his associated entities, or was aware of the alleged influencing of the first accused, the alleged obtaining of assistance from the first accused, the alleged obtaining of the first accused's approval, and the alleged preventing of the discovery of the benefits. Furthermore, to have acted in concert with Sheikh or to have actively associated itself with Sheikh and or his associated entities as alleged, the second accused must have been aware of the benefits to the first accused, and with that awareness participated or actively associated itself in the actions of Sheikh and or his associated entities in giving the benefit to the first accused. The second accused did not participate in or actively associate with the alleged benefits to the first accused and was not even aware of the alleged benefits to the first accused. Count 5, which is specific corruption. Count 5 is the so-called specific corruption count and is premised on a meeting of 10/11 March 2000 in Durban, which gave rise to a document which has since been referred to as the alleged encrypted facts. At that meeting, Sheikh's request for payment of 500,000 rand was confirmed by Sheikh. The request by Sheikh was not accepted nor agreed to, and no payment was made in consequence of Sheikh's request or at all. It is further denied that the first accused performed any act as alleged in this count in pursuance of the request by Sheikh or at all. Count 6, money laundering and the alternative thereto. This count is premised on the state's allegation that the Service Provider Agreement, SPA, entered into between Thales Mauritius and Kobifin was an agreement to disguise the bribe payments allegedly agreed to at the meeting of 10/11 March 2000. It is denied that the SPA was a disguised agreement as alleged or at all, but it was an agreement in terms of which Kobifin would be paid an agreed remuneration of 500,000 rand in 2 installments for the performance of stipulated services by Sheikh to give effect to the work share requested. The first payment in terms of the SPA of 250,000 rand was made on 16 February 2001 and was not made to the first accused, was not intended to be for the benefit of the first accused, and did not benefit the first accused. The SPA was concluded as Sheikh's requested that he or his entities could bring additional support to Thales, and the terms of the agreement are included in the SPA that was subsequently concluded between the parties. Pursuant to this request, it was agreed that Sheikh, through his entity Kobifin, would be appointed to identify new business opportunities for Thales/ADS, with the hope that Nkobi would participate in the work to be performed pursuant to the introduction. For this service, he would be paid a fee. This arrangement was to be recorded in the form of a service provider agreement. In November 2000, the parties were still in the process of negotiating the terms of the SPA. The second accused subsequently established from documentation made available by the state and the evidence of Minister Mkhize at the Sheikh trial that Sheikh's efforts to expedite the conclusion of the SPA was triggered by the following. On 17 October 2000, Mr. Mandela paid 2 million rand to the first accused, of which 1 million rand was for the Zuma Education Trust and 1 million rand was earmarked for reparation to the King's Royal Residence through Development Africa, for which an account would be opened. The 1 million rand that was to be deposited into the account of Development Africa when opened was in the meantime paid by or on behalf of Mr. Mandela into the first accused's account because he was seen to be instrumental in bringing peace between the ANC and the IFP in the province. At that stage, the bank account of Development Africa had not yet been opened. On 18 October 2000, Sheikh, without authorization, unlawfully withdrew 900,000 rand of the 1 million rand earmarked for the royal residence from the accounts of the first accused and paid it into the accounts of his entities to reduce their respective overdraft liabilities. On 6 December 2000, the first accused, unaware of the withdrawal by Sheikh, issued a cheque in favor of Development Africa for the amount of 1 million rand. On 7 December 2000, Sheikh, upon learning of the issuing of the cheque, stopped the cheque as he knew that there were insufficient funds to honour the cheque. Minister Mkhize, as a trustee of Development Africa, confronted Sheikh about the stop cheque and requested that he pay the money that he had withdrawn from the account of the first accused into the account of Development Africa. Sheikh gave Minister Mkhize 4 post-dated cheques as he did not have the required funds needed to repay the money he had taken. The above events caused Sheikh to take steps to expedite the conclusion of the SPA in order to obtain funds to repay the money he had taken from the first accused, which was earmarked for the reparations to the King's Residence via the Development Africa account. Thereafter, Sheikh made a payment of 250,000 rand to Development Africa. The second payment of 250,000 rand in terms of the SPA was not made because Sheikh had failed to perform in terms of the SPA to qualify for the second payment. The payment made under the SPA was made from lawful funds in the hands of Thales Mauritius and not from any funds constituting the proceeds of unlawful activities to constitute money laundering. The SPA was not designed to conceal or disguise the nature, source, location, disposition, or movement of the funds to constitute money laundering. It is then, my Lord, dated today and signed by Pietermaritzburg Durant, the representative of the second accused.
Yes, thank you. Mr. Durant, you've heard what is read out and you've signed this document. You're familiar with its contents and you confirm the correctness thereof, do you?
Yes, ma'am.
Thank you. Yes, Mr. Ree, anything further?
Nothing further, thank you, my Lord.
Yes. Mr. Dana, I interrupted you earlier on. Did you want to say something about the proceedings at this stage?
Yes, my Lord. I think we've reached the stage where normally if a 106.18 plea had been tendered, we would now go into adjudicating that.
Yes.
The state would have a right of reply. We've preempted things because we've now already decided that this will be done by the exchange of papers. So all I wanted to say was that my learned friends have put on record a flavour of what is to come, and it will be duly argued. Naturally, we are busy with papers where we dispute what has been put on record,
yes,
both factually and in terms of conclusions to be reached. And we are busy doing that, and we'll present to the court fully.
And that'll be ventilated on the 19th of July?
On the 19th of July.
Yes.
And our papers will say that, we'll dispute it, and so on. So we do not at all accept what has been said, and we'll in due course dispute it. I'm in a bit of an invidious situation because I am the target of the attack, and my counsel are not here.
Yes.
So counsel will be here on the 19th of July in order to take the matter forward.
No, I understand that, Mr. Dana. That's why I try to keep the address is important. It's important that one understands the basis for it, and I think we've been told what the basis is. But to the extent that it referred to specific factual allegations, obviously, well, presumably those are in dispute, and you will have the opportunity to deal with them, and ultimately it'll have to be adjudicated upon.
Indeed, my Lord. I'm indebted to the
Yes.
court. So I think then, as proceedings go now, we've all agreed that the 19th of July will be a date of hearing. So I propose then that there'll be no reason to have the criminal matter appear at any time before the 19th of July. So I would ask the court to postpone the matter to the 19th of July, and we will give the court the note which sets out the timetable for the exchange of papers.
Well, I do have it. I'll record it as part of a consent order. Is that in order?
That's quite in order, my Lord, yes.
Yes,
so
Mr.
that is from us, our submissions.
Thank you, Mr. Dana. You wanted to say something, Mr. Mpofu?
My Lord, yes, my Lord, I'm sorry, my Lord. My Lord, of course, we have already confirmed the date arrangement. What I do want to place on record, my Lord, is the following. It's something that we mentioned in chambers, that although we have filed an affidavit and we have agreed on exchange of times and we'll have an answering affidavit and a reply in the normal way, we want to place on record, my Lord, that it is our firm view that some of the disputes, and of course we might be pleasantly surprised when we get the answering affidavit, but that some of the disputes will require some element of oral evidence, my Lord. To that extent, and as your Lordship knows, just under the normal Rule 6, if the applicant foresees disputes of fact, then it would ordinarily not even be allowed to proceed by way of application. But these are sui generis type of proceedings. We will engage with our learned friends, particularly once we have received the answering affidavit. Because as I say, my Lord, it might well be that it turns out that we are wrong. But we would, our prediction is that we're not wrong. Once we have received the answering affidavit, we will then engage with our learned friends to see how that matter might be handled without having to waste time. In other words, we don't have to want to come here on the 19th and debate that point. If possible, we'll make some kind of interim arrangement so that the 19th remains the firm date for the actual argument. So, and of course, we'll have to engage your Lordship. If we cannot resolve it among ourselves, it might well mean that there'll have to be some interlocutory stage before the 19th. But we will keep your Lordship posted, and if there's correspondence between us on that issue. But I just thought, my Lord, I didn't want to spring it up on the 19th. We will try and manage it, at least as senior practitioners, as best as we can.
Yeah. Mpofu, yes, I don't want to anticipate argument or debate the matter now. But what is before the court at the moment as an issue is the plea, let's call it a special plea or whatever, in terms of 106(1)H. It seems to me that it's probably a prudent way to exchange affidavits regarding that. But whether there's a material dispute of fact which is relevant to adjudication of the issue might depend on legal arguments such as whether a narrow or a wider meaning is given to title, for example, in that section. So factual disputes, as they might or might not exist, might have to be resolved or they might not have to be resolved. So I don't know that one should anticipate those. I think first you look at the affidavits, and then we probably have to leave it to you and your opponent on that date to argue firstly any preliminary legal issues. When I say preliminary, they're not really preliminary, they're the substance, they're the merits, as to what the section means, whether title is confined, as you said earlier on, to something like a certificate that you need, or whether it goes wider, and if it goes wider, how much wider. And because it seems to me that the case law on 106(1)H is fairly limited. Yes. It's a fairly novel sort of area, if I may call it that.
Yes,
but as I say, I don't want to debate it.
Right.
The present is not a recusal application. It's the plea. Yes. It's the plea stage. We've reached the plea. Plea was entered this morning. And what's to be adjudicated is 106(1)H, what it means and all its ramifications and implications.
That's correct.
And I think let's perhaps just leave it at that for the moment, because a factual dispute, if it exists or doesn't exist, might or might not be relevant. But that might have to be debated still on the 17th.
The Lordship, I agree 100%, my Lord. The factual disputes, of course, would be subjects of Plascon Evans and so on, which doesn't apply to the legal disputes that your Lordship is correctly pointing out. Yes, my Lord, your Lordship, I agree, my Lord. The cases are quite few. We have found the cases of Delport and Porritt in the SCA as cases that are in point.
Yeah, Delport, at least in Porritt's cases there, but they... well, let's not debate it now.
Yes,
they have
we'll have ample time for that.
Yeah, there's going to be...
Lord, yes, just I agree 100% with your Lordship. All I was really placing on record, my Lord, is the rule that really applies to normal motion proceedings, that the applicant has a duty, if there are foreseeable material disputes, to not to even go to motion court. We are aware that these are not your normal motion proceedings, but we just wanted to place it on record.
Yeah, you see, that's another difficulty that's introduced.
Of course.
I'm not even sure whether it's quite a Plascon Evans type situation.
I doubt it.
We will have to, well, I'll hear argument in that in due course. And then we also have a, you're no doubt aware of it, a fax directories case in this division.
Yes.
That if these were to be civil proceedings, that if a party doesn't, an applicant, and it says an applicant, not an accused, does not raise the possibility of a referral to oral evidence at the outset, that he won't be penalized by having the application dismissed.
Yes.
But as I say, we're now talking civil law.
Yes.
And to what extent it applies to the adjudication of a, and I'm going to refer to it as a special plea, and excuse me, I think it's probably an apt description, but it's just going to be so much easier to refer to it as such from now going forward. But there are many issues to consider regarding this special plea.
And those issues themselves might be debated.
Yes.
As court pleases.
Mr. Roux, final word, nothing to add?
Just the same, nothing to add.
Thank you, Mr. Roux. Yes, by consent then, I grant the following order. The matter is adjourned and the two accused are warned to appear again before this court on the 19th of July 2021 for the adjudication of the plea that has been raised by the first accused in terms of section 106(1)(h), I beg your pardon, of the Criminal Procedure Act 51 of 1977. 2, the state is directed to deliver its answering affidavit by close of business on the 2nd of June 2021. 3, the accused number 1 is directed to file his replying affidavit, if any, by the 9th of June 2021. 4, accused 1 is directed to file and deliver his heads of argument in regard to the plea in terms of section 106(1)(h) on or before 5 July 2021, and where have we now on the numbering, 5 or 6, 5 I think it is, the state is directed to deliver its heads on the issue to be adjudicated by the 12th of July 2021. I think that covers everything, Mr. Dana. Yes, Mr. Mpofu, happy it covers everything?
As the court pleases,
and Mr. Roux?
Yes, ma'am.
Very well then, the matter is adjourned accordingly. Court will rise.
Thank you.
Thank you.